The defendant, Frank Machaw, steps into the courtroom with a challenge right off the bat. The judge quickly shuts down his attempt to play the sovereign citizen card, telling him in no uncertain terms to sit down and proceed like everyone else. The tension in the room is palpable as the judge exercises full control, setting the tone for what's about to become a no-nonsense battle of wills.
Good afternoon, Your Honor. Mohammed on behalf of the people, P86771.
No, it's not. You have work, so
Yeah,
you're on side here.
Are you up? Please sit at the desk representing yourself.
The judge needs to address you, sir. Is that a problem, sir?
Yeah, you're a defendant. Sit at the defendant's chair.
I'm not defendant. I'm sorry.
Judge, if I may try to help explain.
Try.
I'll try. Mr. Michaud is a sovereign citizen, and
No, I object. I'm not a sovereign citizen.
All right, sir, don't speak.
I maybe am not phrasing that correctly.
Don't speak until I ask you to speak.
But there is a difference between Frank Michaud, or I think it is Mr. Michaud's assertion that there is a difference between the natural person, Mr. Frank Michaud, and the sort of legal entity.
I don't recognize that.
And that's what I've prepared Mr. Michaud for that.
Sir, you're a defendant in my courtroom. Either I issue a bench warrant because you haven't appeared, or you come up here and sit in the chair and we proceed.
All right, so you're threatening me to.
Absolutely, I'm threatening you. Either you're here today or you're not. If you're not here today, a bench warrant will issue. If you're here today, I need you in the chair so we can proceed with the proceeding that's scheduled, which is a preliminary exam.
Things escalate quickly in this clip as the defendant insists on his jurisdictional argument, while the judge tries to keep the situation under control. The defendant's claims are met with disbelief and frustration from the judge, who demands a direct answer, cutting through the confusion. You can feel the heat rising as the defendant tries to assert himself, but the judge's firm ruling leaves no room for doubt about who's in charge here.
So you want to represent yourself for that jurisdictional argument, and if I rule against you, then perhaps you want him to represent you? Is that what I'm hearing?
No, that's not what you're hearing.
All right, so you don't want him at all under any circumstance?
No, I don't need an attorney.
In the third grade. Well, I don't need it.
Okay.
So with that being said.
Well, hold on. You can stick around if you want to, but I'm not going to obligate you to stay.
I understand, Judge. I'm definitely going to stay.
That's fine. All right.
So today,
you have a jurisdictional argument you want to make?
Well, I've served notice.
Sir, it's a yes or no. Do you have a jurisdictional argument you'd like to make today?
I have a
yes or no.
Why are you forcing me to say answer?
Because I'm running the courtroom and it's the way I want to do it. Do you have a jurisdictional argument you'd like to make today?
I do, yes.
Then make it. What's your jurisdictional
argument? I'm presenting myself. So I need to know, Article 6 of the Constitution grants me the right to know what jurisdiction is this court operating up under?
State of Michigan.
No, what jurisdiction?
State of Michigan.
Okay, what jurisdiction is the state of Michigan?
District courts are legislative courts. That means they're created by statute. The state of Michigan gives me my jurisdiction.
So, okay, is that
I work under the authority of the state of Michigan.
What is it? Under what jurisdiction? There's two different jurisdictions under the Constitution. You have admiralty and common law. So I'll need to know.
This is not admiralty.
What is it?
And it's not common law. It's statutory.
Okay, so it's statutory. That is what? Civil?
No.
So what is it?
My jurisdiction is both civil.
I can't defend myself unless I have it on the record.
In this moment, the defendant's refusal to understand the law reaches its peak. The judge calmly but firmly breaks down the legal terms, making it crystal clear that his arguments hold no water. The back and forth intensifies as the defendant's attempts to deflect are met with a steady stream of legal reality from the judge. The defiance is palpable, but it's clear the judge's authority will not be shaken.
Is it
my jurisdiction?
It's only two.
Sure, shut up. If you ask me a question, I can't answer while you're talking.
Okay, cool.
My jurisdiction is both civil and criminal as provided by the statutes of the state of Michigan.
Okay, so today, under which one is
this? Is a criminal case.
Okay, right. So is that common law or admiralty?
It's statute. It's neither common law or admiralty.
It's one or the other. It don't say statute.
All right, then you can appeal my ruling. My ruling is it's neither admiralty or common law.
So this is you say it's criminal for the record?
Yes.
Okay, and if it's criminal, in order for a crime to exist, there must be an injured party for the record, right?
There must be what?
An injured party.
Yeah, it's the people of the state of Michigan.
All right, so if the people of the state of Michigan, right? Where's the sworn statement?
Where's what?
A sworn statement. I have a right to see a sworn statement saying I injured someone.
There's a complaint in the file.
Sworn complaint, signed,
you want to see it?
Affidavit, sworn affidavit?
No, it's not. I don't think it's an affidavit.
Well, okay, so.
You said you wanted a sworn complaint.
From an injured party. Who have I injured for the record?
The state of Michigan.
How can I
are bringing the charges?
How can I injure the
state?
Sir,
sit down. Sit down.
I'm not.
Sit down, or I will hold you in contempt.
Another threat. Wow.
You're probably going to hear more than one.
Here, the judge doesn't miss a beat as the defendant continues to derail the proceedings with irrelevant objections. The judge delivers a scathing reminder of courtroom decorum, making it clear that he's not going to tolerate any more disruptions. His authority is unyielding, and as the defendant tries to persist, it's evident that the judge has no intention of backing down, no matter how many objections are thrown his way.
All right. I am ruling that I have jurisdiction. You are free to appeal that to the circuit court. Proceed. Do the people have a witness they'd like to call in the exam?
Yes, Judge. The people are prepared to move forward. Just as a quick preliminary matter, we'd request a mutual order of sequestration with an exception for the OIC.
All right.
So again,
I'm not asking you to talk. Ma'am, are you a possible witness in this case? Okay. All right. And would you mind putting your name on the record, please? Counsel, I want to look at the lady. Would you mind putting your name on the record?
she's a witness. She is a witness.
Sir, you speak again when I haven't asked you to, and you're in contempt. And we'll deal with that first. The reason I need your name is because if you appear somewhere down the road and want to testify, we have to know that today you were in the courtroom. And I can't do that by taking a picture of you. So I'm asking you to state your name.
Your witness. Yes.
Sir, you are in contempt of court. That's a $100 fine. Speak again when it's not your turn, and I'll continue to up the ante. Clear? You can speak now. I've asked you a question.
I object.
I don't give a shit if you object. Is it clear what I said? I'm waiting for an answer.
I said I object. What am I supposed to say?
I want to know if you understand you've just been fined $100 for contempt.
I don't understand.
Okay, well, you still owe me $100. Are you going to give me your name? That's fine. Thank you. Witness.
Your Honor, the people called Officer Steppen. Oh, I'm sorry. One last quick preliminary matter. Pursuant to 76611D, we'd like to introduce a certified registered of action in regard to this individual being a previously convicted felon.
I object.
Hold on. Have you showed that to him?
I object. I object.
What's your objection, Mr. Michaud?
My objection is that I am here under the guise of probable cause conference. And I don't know how we're here at a preliminary exam when I did not.
The stakes are getting higher now. The defendant still refuses to accept the legal framework, and the judge, maintaining his composure, forces him to confront reality. The judge's patience wears thin as he draws the line, making it clear that his courtroom will run on the judge's terms, not the defendant's. This is a classic moment of a judge asserting complete control, and the defendant's defiance is only digging him a deeper hole.
Am I right? Do I have a right to a probable cause?
That's what today is scheduled for.
But today it says preliminary exam. Right here it says probable cause conference, and today is a different date that says a preliminary.
Have you ever had a grilled cheese?
If it was different.
Have you ever had a grilled cheese?
If it was different, why would it have two separate
Have you ever
columns?
had a grilled cheese?
I object to any of that. Why would it have two separate columns?
Take him out.
Why would it have two separate columns?
I'm not playing this game with him today. If you think you can get him to shut up long enough so we can have our hearing, we'll do it. But I'm not going to let him try to run my courtroom.
Okay, I'll just be very brief in my one attempt here. I would like to try to explain what I understand Mr. Michaud's objection to be, and what I have also represented to him regarding that objection. Mr. Michaud, I think the court record will reflect, had a probable cause conference first on November 29th and then again on December 20th. I have disclosed, I mean, I think I've been very transparent with Mr. Michaud that probable cause conference is a bit of a misleading name because probable cause conference under the court rules does not require that probable cause be established.
Right.
At the second probable cause conference, Mr. Michaud was caring for a sick relative, so he wasn't able to attend that probable cause conference scheduled December 20th.
Which didn't hurt him at all.
Right. I represented him on that day, and I asked the court to waive his appearance so that he could remain with his family.
Which we did.
Understood to be his wishes. I may now understand differently that I misrepresented him in some way, but my goal was just to be able to conduct a probable cause conference where we were going to find out if there was any offer, whether discovery.
You don't have to tell me what they are. I know what they are.
I know, but I'm just trying to.
And I'm trying to explain it to him too, but I'm not going to talk over him.
Right.
And I'm not going to play that crap today.
Right.
So if you want me to explain what's scheduled today versus what was scheduled last time, I'm happy to do that. But you got to be quiet while I'm talking. Clear?
This clip captures a pivotal moment where the judge lays down the law in a straightforward, no-nonsense manner. The defendant continues his futile attempts to argue, but the judge is calm. Precise responses leave no room for interpretation. It's almost as if the defendant is trying to wear down the judge, but it's clear the more he speaks, the deeper he digs himself into trouble. This is judicial authority at its finest.
Oh, dude, I hear you.
All right. The last court date that we call a probable cause conference is like a pretrial on a misdemeanor. It gives the parties a chance to discuss the case and see if there's any resolutions prior to the next step. Next step being preliminary exam. At the preliminary exam, the people have to prove to me that there's probable cause to believe that there was a crime and there's reason to believe you were involved. That's what's scheduled today. That is a probable cause hearing. Probable cause conference is just a name that we all came up with instead of saying it's a pretrial for a felony. Do you have any questions based on that? You can do that right now. Do you want to make a deal with the people?
I want to be able to prepare myself for the probable cause conference.
There's no preparing for a probable cause conference. It's a conversation.
It still takes preparation.
You want a PCC? Go out in the hall and have a PCC with the unrepresented defendant.
Judge, just for the record, there will be no offer at this stage.
There's your PCC. Now, do you want to plead guilty? Do you want to have an exam? And at the exam, he's got to prove to me those two things I just said. Probable cause to believe a crime was committed on this date and reason to believe that you were involved. Do you want to have that hearing so he has to prove his case?
The defendant's objections hit a wall as the judge calmly shuts him down, pointing out the absurdity of his arguments. The tension in the room is palpable, but the judge remains steady and firm. The defendant's deflections are met with a stern warning, and the judge's decision is clear. There's no escaping the reality of the courtroom. This clip is all about the judge flexing his authority with precision and power.
That's another option. Would you agree with that assessment, Mr. Sullivan?
I would agree, and I would also just add that Mr. Michaud has made his arguments today, he ruled on his arguments, and that he preserves his right to—
He can appeal them.
As you've already said, at circuit court. And so if he wants to sort of move forward on that defense alone, that, the waiver does not preclude him from
not at all
arguing jurisdiction at the circuit court level. But likewise, if he holds a preliminary exam today, holds the people to their burden, he also maintains the right to, continue his objections to jurisdiction, to appeal the court's orders regarding jurisdiction at that next level, at the circuit court level, assuming that the people are able to prove probable cause today.
Now, do you want to have an exam today?
Well, I wanted to address some, I served the court some notices.
I haven't read any of that because you were represented by counsel.
No, I wasn't. I don't have any contract.
As far as I knew, you were represented by counsel.
Okay, so now you know. And I served the court notices. And I would like to—
First notice, what would you like to put me on notice about?
Well, I served you notice that I requested the criminal bonding information. I requested
criminal what?
Bid bond.
Hold on.
I requested the bid bond, the performance bond. I have an affidavit.
There is no bond.
There are bonds. This is
okay, listen. You can't tell me something and then just disagree with me and figure. Listen to me. Sir, I am not going to let you interrupt me.
The defendant tries once again to throw the judge off course, but it's clear the judge's patience is running out. He snaps back with sharp, direct responses, making it crystal clear that the courtroom will proceed under his terms. The defendant is visibly rattled, but it's too late. His refusal to comply is only making the situation worse. This moment is a clear demonstration of a judge's power to maintain control in the face of defiance.
There are no bonds required for me to do what's scheduled today. I've been doing this 25 years. I've never had a bond.
You have a bond.
Okay, I have a bond.
Everyone here has a bond.
Not in any definition I know. So let's get to the point. Do you want an exam today?
No, I really want to address, okay, so.
I'm not addressing any of that crap you got in front of you.
Well, since you say you don't have a bond, can you express that in a via affidavit so I can have a.
It's on the record. Order a transcript. I'm not signing anything for you.
Okay. Also, I want to also address that. I sent a affidavit of fee schedules for violation of any of my rights.
There are no fee schedules.
Well, I gave you notice and.
Great, then you gave me notice. Doesn't change anything. We still scheduled for an exam today.
Yes, just put it on the record that I served you notice, okay? Also, I served you notice on my power of attorney.
Okay, you said that.
Right, and
move on.
You haven't responded to that, as well as my indemnity bond, which separates me, and I have a private capacity. I am not the artificial person.
I don't recognize any of that.
United States citizen. I am actually
hold on, stop. You can put on notice what you sent the court if you want to make a record of that. But I'm telling you, I don't recognize any of that stuff you're talking about. I don't recognize that you're not really Frank Michaud. Okay, I understand that's what you're trying to argue, but I don't recognize that.
Under what law could you represent or you can use tell me that, not just from what you say, because ignorance of the law is no excuse for you or nobody else. So what you're saying just don't mean nothing. I need to have facts.
Okay, well, it does mean, hold on. It should mean something because.
Prove it, please prove it.
Can I prove what?
Prove that I am not that I am the artificial person.
I can prove you're Frank Michaud.
I have full faith and credit.
I can prove.
Okay, so.
Hold on. You've asked me. I can prove you're Frank Michaud. You know how I can prove that? Because when I called the case and said you either come up here and be Frank Michaud or you leave, you came up here. And you proved it for me.
You threatened me.
But if you're not you, the threat means nothing.
Here we see the judge's frustration reach its peak. The defendant's incessant interruptions lead to the ultimate consequence: contempt of court. The judge wastes no time in issuing a fine and making it clear that the defendant's behavior will not be tolerated. The defendant's defiance is met with the judge's cold, calculated response, showing that no one is above the law, not even a sovereign citizen trying to derail the proceedings.
Okay. But you're still threatening me, and you're using it under color of law.
Okay, listen.
And plus
listen to me, Mr. Michaud.
You have.
I've wasted too much time with you. Yes or no?
So,
sir, don't argue with me. Yes or no? Are we doing a preliminary exam today? Yes or no?
I object. I will address.
Answer the question.
I want to address other issues as well.
You're in contempt of court. Put him in jail.
For what?
For contempt of court.
I'm having.
You can appeal that too. Sentence is 30 days. See you in 30 days.
I object to that. That's
I'm happy to hear your objection.
Due process.
Appeal me. That's why circuit court judges have jobs.
Definitely.
Take him out of here.
Under color of law.
I can give you more than 30 days. John, ask the wife to come in so he can see his property go to his wife. Ma'am, would you accept some personal property from your husband, please?
That was an extreme amount of patience.
Good try.
I appreciate you, giving him as much latitude as you did.
I just can't let him run things. I'll let him engage me, and I don't mind that, but I just can't let him try to run things.
Yeah. No.
Especially when I got 3 or 4 more exams to do.
Right.
The internet is the worst thing in the world for these guys.
I tried to tell him.
It don't play here.
The court is going to deny your objection. Let's allow this to move forward. He might have been able to win this.
And that's the worst part about all these cases, right?
Yeah.
Because sometimes they've got a chance if they just
We had a good
Ron White,
argument.
Ron White, right?
Yeah.
Got a constitutional right to remain silent, just can't do it.
In this final clip, the defendant's futile attempts to argue are fully rejected by the judge, who delivers the final blow: jail time for contempt of court. The defendant's continued defiance in the face of a clear ruling leaves him no choice but to face the consequences. The judge's decisiveness in the face of chaos is a perfect example of courtroom authority, and the defendant's delusions of control are finally shattered. And that's a wrap for today's video. What a courtroom drama, right? If you enjoyed this intense legal showdown, make sure to hit that like button and subscribe to the channel for more explosive courtroom moments. We'll see you in the next video.